All right. Hi, everybody. Thank you so much for being here live. And just thanks everybody for coming. And even if you're watching this later, I appreciate everybody joining and watching. And I hope that you're going to get a lot out of this session tonight. So, my name is Maureen. I'm the founder and creator of Bar MD. We're a full service bar prep company and we handle most states, California, all the UBE. We do get a lot of people also that take UBE components, whether it's Georgia or Florida or whatever state it is. So, we can pretty much help you and if you're working in just about any jurisdiction to take the bar exam. And we have everything from full complete courses, everything you need, essays, PTs, MBEs to piecemeal if you just want to focus on one thing. We also have books and just really everything. Um, so anything you need, we are here to help show you how to pass the bar exam. That's really what we focus on at Bar MD, is not just like throwing a bunch of content at you, saying like, all right, here, not you make sense of it. I don't think that's what other companies necessarily do. But really putting the onus on you to figure out, okay, how do you take a perfect answer and figure out how to write a passing answer? So I always want to show you how to really adequately, and we're going to go through a few multiple choice questions today. How do you adequately, get everything you possibly can from every practice multiple choice question? How do you actually determine if you're writing a passing answer or not? All of that stuff. How do you actually analyze an equal protection issue? For example, we're going to look at that today. So we like to just show you how, and also with our classes coming up, there's going to be a lot of accountability involved as well. So a lot of exciting stuff coming up that I think is going to be really helpful for those of you that are just going on this bar prep journey for February 2026 or even later. I have some people that start early for July. So, and please just excuse me today. I'm just a bit under the weather, so I might have to pause, etc., a little bit more today than normal. All right, let me get this. Uh, let me get this up, my PowerPoint. I always do that. All right. So today, this is our last of the free series that it's like this exact series. Just as a heads up, we do have a lot of free webinars that we are going to be doing still coming up. Not one every single week, but just for everybody that's here now, we do still have stuff coming up next week. Next week, for example, we're doing a review of the July 2025 UBE. So that I think is next Wednesday, where I'm going to walk through the 6 essays and the 2 PTs. The week after that, I'm going over the California bar from July 2025. I'm also doing in a few weeks, I'm doing on November 19th, I am doing a webinar talking to you and showing you guys how to use ChatGPT to grade your essays and PTs effectively. It's one thing to throw them in there and get some feedback, but it's wholly another to actually do it well. So I've been working on this for the last few months, really trying to sharpen this and then do something so that you guys can use that tool to really get immediate feedback. And one thing I would like to say is that, this isn't necessarily, using ChatGPT to grade your stuff. I don't think that will replace a tutor necessarily. I still think you do want, if you are someone that is looking to hire a tutor, if you've had continuous issues with um, with your essays, etc. Um, um, you know, um, yeah, I don't think that it will. Sorry, I just lost my train of thought for a second. I don't think it will necessarily replace a tutor who really has all the law knowledge, all the skill, knows how the grading works. If you have an effective tutor, that is. Um, that somebody that can actually do that very well. But you can use like Chat GPT or another tool like that to get feedback for everything that you're right, where a tutor can't do that. Even when I'm tutoring someone and I have them do, in a single session, in a tutoring session, I can go through 3 or 4 essays, PTs, some MBEs, etc. Um, and I can do it very sharply and show people how to fix it. I can't do all of, the essays if you're writing an adequate amount of essays. So just throwing that out there. But so today we're going to cover a few CONLA MBEs. We're going to spend more time on the MBE today, and I'm just going to do a little bit on the essays. Remember, in the full courses, we have a full course for the MBE. Well, we have our full bar prep program. It's our core program. with MBE. You can also do it without if you really feel like you just want to work on the writing with us. That's okay too. Um, but I encourage anybody, even if you did get an okay MBE score and you're retaking the whole exam, but you feel comfortable with the MBE, I'm sure that we can show you stuff to help you do even better with it because I do go so in depth into it. So again, those classes start in a few weeks. They start, I think, November 17th. Um, we're going to have that. And then the essay class, we're going to cover two essays in each subject throughout the series, throughout the course. So every week is a different subject. I always start doing kind of big picture of the subject, and then we're going to dig into a couple of essays. In all of the classes, we have a PT one too. And in all of the classes, you have to show up having done the work. So there's really that sort of fire under you, that accountability under you to, and a lot of people need that. I need it. I have accountability people to help me also. So it's a huge part of what can like really help you succeed. And for anybody that sort of struggles with that, I also like to just say, like, I struggle with it too. You know, it's like why people have a trainer when they go to the gym. You know, it's helpful in so many different aspects of our life. But when you have like a big thing, like a big task, like the bar, it can be really helpful to have that accountability component, particularly if you're retaking it, because there's so much of it that's just alone. And no, the classes aren't free. No, those ones are not. Those are my paid courses that I'm talking about. This is just sort of like those on a very, very light scale. Is these are just sort of like a little an amuse bouche or just like a little nibble of a sample of what the full courses are like. I go sort of nuts in my full courses. I try to really not leave anything. I'm really thorough in the courses. So today we're going to dig into the MBEs a little bit more because there's three for the con law, and then I'm going to talk about equal protection for the essays as well. Um, all right. Um, so if you guys did the questions in advance, I'm going to put the poll up on the screen. I'm so excited. There's so many people here. I'm going to put the poll up on the screen. Please tell me which answer you picked. And I put the poll up. And then we're going to walk through this question. And everybody put in your answer. All right, take another 10 seconds. All right. All right. So answers are pretty mixed here. It's very interesting. Um, very, very interesting. So we got answers in all four for A, B, C, and D. All right, let's talk through this. Let me get it up on my iPad and we're gonna talk through this a bit. Give me 1 second to switch over. Oops. All right. Um, So, which of the following statements about this law is most accurate as a matter of constitutional law? So, this is sort of a funny question because it's super short. I hate these where it's really short and really all of the information is in the answers. I don't know why. I just personally dislike these. So, all right, let's look at the fact pattern too. To keep its public expenditures under control in a time of increasing costs. So, we're looking at economic protectionism or just trying to save money. Usually you can't do stuff with that as the justification when it involves, preventing someone from like a fundamental right or engaging in something that they're entitled to. So this is the money factor. Um, a state passed a law providing that children who have not lived in the state, so we're talking about residency requirements, durational residency requirements, for at least 1 year cannot attend public schools in the state. Okay, so we're talking about um, durational residency requirements, which this usually gets at privileges and immunities. There's a couple different things I'm going to talk about there because people get them always mixed up. I get them mixed up too. I'm like, which is which? There's two. There's privileges and immunities, privileges or immunities. One's the 14th, one's the 4th, I think. Um, so we're going to talk about this in just a second. So this is a residency duration. Okay, so I'm thinking P and I. Okay, so let's just walk through each of these. So A, the 1 year residence requirement is valid because it does not affect any fundamental right or suspect class. So a couple of problems with this. One, a residence requirement isn't valid just because it doesn't affect a fundamental right or suspect class. Also, so that statement is like just broadly speaking, it's incorrect. Number one. Number two, this does affect a fundamental right. Does anybody know what fundamental right it is? So you got to know all of your fundamental rights. This is a big one. Whenever we see these durational residency requirements, it usually implicates the right to travel. Yeah, the right to travel, which some people are typing in. So this, I think it's just too broad of a statement. It's kind of getting at an implied absolute. Um, it's getting a bit at an implied absolute, but not quite. But the residency requirement is not valid just because it doesn't affect that. You'd want to look for like a basis that actually does give it authority versus something that's just like, well, it doesn't violate, so it must be valid. So a bit of like a logical flaw there, but it does involve the right to travel. B, state durational residence requirements that are established for publicly funded services are constitutional because they relate to governmental operations reserved exclusively to the states by the 10th Amendment. So this has a few things wrong with it. Um, this is what we call an implied absolute. Is it always, there is an implied always in here. So is it true? Is it always true that state durational requirements, residence requirements that are established for publicly funded services are constitutional because they relate to government operations reserved to the states by the 10th Amendment? No. Like that is definitely not always true because if they violate if they violate, for example, the fundamental right to travel, then they're not permitted. So, so that is not, there's an implied always in there. That statement is not always true. Um, yeah, so that's not always true. So it's just legally incorrect um on that for that one. So let's just say um legally incorrect, not always true. So I just making a note here. And I go more into implied absolutes in the class as well. I think we've also done blog posts about this too. It's a really common thing and so many people miss them. So, all right, let's look at C. C, because publicly funded education is a fundamental constitutional right, it's not. A state may not deny it to any class of persons who reside in that state. So that's not true. It's publicly funded education is not a fundamental constitutional right. I think what gets a lot of people is it sort of sounds like it is because kids are required to go to school. Um, but there is not an actual fundamental right to it. So if you pick C, you need to make a list and check and make on your card of like flashcard of fundamental rights. You need to make a note that there is no fundamental right to a publicly funded education. It's just actually a problem that like if your kids don't go to school, you can get in trouble or the kids can get in trouble. The other part of it is it's related, but parents have a right to choose. It's like the fundamental right to child rearing to choose where your kids go to school. You don't have to send them to public school. You can send them to private school. You can homeschool them, etc. But they do have to get an education. So a lot of people kind of conflate that with a fundamental right to an education. So D is our correct answer. And I want to just look at some stuff in D. Let me just make this note. Okay. Okay, so D, state durational residence requirements established for this kind of publicly funded service. So do you see, everybody see how much more specific D is than anything else? They're talking about this specific kind of publicly funded service. So that type of detail is a much more precise answer. And then let's keep going. Solely for the purpose of reducing state expenditures, that gets back to that thing where I was like, there's some economic protection here, which we usually can't use to infringe on citizens' rights or people's rights. And then it also gets to the privileges or immunities clause. So, for the purpose of reducing state expenditures, violate the privileges or immunities clause of the 14th Amendment. So this D is our correct answer, which I think the majority of people pick 52%. But a lot of people miss this one, and understandably so. There's just I think I don't like these types of questions that where it's really all in the answer options, the facts. But the specificity is what's really big to me and what really stands out in D. All right, so just going back to my PowerPoint here for a second. So So again, the 1 year residence requirement. So A, it's incorrect. It forgets about the fundamental right to travel. And also something not affecting fundamental rights or suspect classes does not make it constitutional. There's just a little hanging A there. B, again, incorrect because this is getting at the implied absolute. Not all state durational requirements established for publicly funded services are constitutional if they relate to the 10th Amendment, basically. C, again, no fundamental right to a publicly funded education. And if you pick C, and one thing I'm going to talk about in the class is as you do questions, you should have flashcards. Like I actually ordered some, they're in the other room. Ordered like the 5x7s, and you should have, like a flashcard on what are fundamental rights. A really good thing to add from doing problems is what's called a non-example. So like here, you'll just make a note, okay, these are fundamental rights. What are not fundamental rights, but sound like they should be? All right, so right to a publicly funded education, I would add to that list. And so lots of times we're going to get helpful information so we don't get tripped up by that in the future. All right. That one went a little bit faster than I thought. Maybe it just goes fast because I'm talking through it so much. All right, let's look at the next one. Oh, a couple notes on privileges and immunities. I just wanted to put this up here. So just remember this. And like I put this here so you guys can take a little screenshot if you want to. So those privileges and immunities, that's Article 4. Yes, Article 4, not the Fourth Amendment. So that's where states can't discriminate against citizens of other states. So that's like your right to earning a living. So you'll see this sometimes with like a license to practice law. You can, make there be a different requirement, but you can't. It's just like you want to think of that, like a license to drive, a license to do a lot of different, anything. Let's see, privileges or immunities. This is privileges or immunities. This is of the 14th Amendment, and that's the rights of national citizenship. So that's right to travel. It should say right to vote in federal elections. Yeah, and somebody asked, I've gotten a few of these questions, so I'll just address it now. Somebody's asking if you start my core classes late. Yes, anything that is live that has occurred, we record and we post it generally within 24 hours. If it's a Saturday class, it may get posted Monday. All right. This crazy. Now, this is another question that I don't like because it's so long. So long. Oh, hey, Michael. Um, okay, now everybody read through this. I'll put the answers up on the next screen in a minute. Oh, yeah, or I'm sorry, I'll put the answer options up on the screen in a minute. Here. I just couldn't get it all to fit on one screen. Oops. And everybody get your answers in if you look, unless you're waiting for me to slide it to the next page, which I will do in 10 seconds. All right, and then here's the answer options. And then get your answers into that poll in just a minute. All right, get your answers in. I love the participation, so thank you to everybody participating. All right. So let's get to this. Let me get it up on my iPad. All right, so we're going to start with the call to question and we'll get up there in a second. Okay, so the call to question here, this one wouldn't even go on one page. I had to like put it down to the next. Does the court have jurisdiction to review the merits of the case? So this is just asking about jurisdiction, which is why this is one of the instances where you can see how important it is um, to to look at the call to question first to really narrow your focus. So do they have jurisdiction? So we're getting at those preliminary questions. So a man owned a house where he lived with his family. The man was convicted of selling large quantities of an illegal drug from his house, acting under, excuse me, a state law authorizing the destruction of buildings that are used for illegal activity. The city destroyed the man's house. If you hadn't read the call of the question, you'd just be like, what's going on? Um, all right. Um, the man's family then rented an apartment and demanded that the city pay for that temporary residence, which this feels like a little crazy to me. The family relied on a state law providing that any person who was dispossessed of his or her place of residence because of the actions of city officials, and I'm like, well, it's really because of the man, but whatever, was entitled to replacement housing at the city's expense until permanent substitute housing could be found. So one thing I want to point out, so like I am always modeling what's going through my head and like the conversation that I'm having with the question as I do it. And this one could really lead you sideways if you don't know sort of like what world you're in. If you don't know that you're looking at just like justiciability issues and, you know, ripeness, mootness, political question, adequate independent state grounds, all of that stuff. Um, because we're not really getting at can the city do this, et cetera. Like that doesn't really matter here, but it's easy to get kind of caught up in that. So when the city refused to pay the rent for the apartment, the man's family sued the city in a state trial court, claiming a right to such payment under both state law and the Due Process Clause of the 14th Amendment to the U.S. Constitution. The highest state court ruled for the family. Although the court decided that the family had no right to payment under the state law, it held that the 14th Amendment entitled the family to payment of the rent for the temporary apartment. In its opinion, the highest state court indicated that in several of its decisions, it had found cities liable for compensation in similar situations on the basis of the Due Process Clause of the state constitution. But the highest state court declined to base its holding on the state constitution because that issue had not properly been raised in the case. So, what did they make their finding on then? They made it then based on the US Constitution. So, does the court have jurisdiction to review the merits of this case? Do they have jurisdiction, everybody? Yeah, they do. Um, they do. Is there an adequate, so what is this getting at? Adequate independent state grounds. Is this getting at that? So let's walk through these. So let's just start with D. No, because independent state law grounds could have been used. We don't look at that. We don't look at what could have been used. We look at what was used, right? We look at what was used here. So just because it could have been used doesn't mean it's right. We have to look at what was used. Okay. C, no, because the decision of the highest state court renders the case moot. It doesn't render it moot. It's appealable. It's absolutely appealable. So not moot. It's yeah, it's still appealable. Yes, because the federal and state law issues in this case are so intertwined that a resolution of the federal law issues is necessary to facilitate a proper determination of the state law issues. A lot of people pick this answer, and I get why. I get why because I also get why the others as well. But I really get this one too because this has some of the language of independent adequate state ground where sometimes a federal court will still hear a case even though there is an adequate and independent state ground if the federal and state issues in this case are so intertwined, et cetera, et cetera. So this is a familiar rule. Um, this is a familiar rule tied to the issue in this particular problem. It's just that this isn't when that exception applies. Because here, the highest state court based its decision wholly on federal grounds. So there's not an adequate independent state ground at all here because they didn't cite to the state law. Yeah, the issue, and somebody said the issue isn't resolved regarding the mootness of it. Um, so that's where, like with B, that's where these issues can be really tricky. And we see that type of stuff come up all the time. It's an accurate statement of law. It's very precise, related to the issue here, but it's just not actually triggered. So this is where they're giving you sort of like the exception, but it doesn't apply. So you have to be able to really discern between that. Does that make sense to everybody? Does everybody know that that's what they were doing with B? Because I see people miss stuff like that all the time, or people will see that and they'll be like, oh God, like I know that that's not right, but I don't know why. And anytime you have a single question where there's anything in it where you're like, oh, I know that's not right, and I don't know why, you've got to dig into that. Good, Raya. Somebody said that that applying this method that I'm teaching in these sections, in these sessions, has helped them improve their scores. That's the goal. For so many people, it's bringing up their multiple choice like 10 points. And that's requires just this level of detail. Yeah. So again, so A is correct because the highest court did not rely on an adequate independent state ground. The court does have jurisdiction. So B, again, this is incorrect because its rule, while familiar, is not applicable because there is not an independent and adequate state ground. You use this when there is adequate independent state ground. Yeah. And then again, the issue is not resolved for C. Um, and in D, the state's highest court did not rely on state law. And it doesn't matter that they could have used that. So, all right, you guys ready to do the third one? You want to see the poll? Let me share. Pretty big mix here. That one looks like it really got a lot of people. All right, and let's look at the next one. And then you can pick your answer here. All right, well, another 20 seconds for people to answer. All right. So let's dig into this one. This is our third. This is our last multiple choice question for con law. Um, let's dig into it. That should pop up in just a second on the screen. Okay. All right. So is this law constitutional? So a super broad call. So a state law prohibits any barbershop licensed by the state from displaying posters in support of any current candidate for public office. So they are limiting what you can display, which is limiting the content of speech. And this is political speech, which is like super protected, or displaying or distributing any campaign literature in support of such a candidate. No other kinds of poster or literature are subject to this prohibition, nor are any other types of commercial establishments in the state subject to similar prohibitions. So it's like just barber shops. Are they a protected class? No, but there is a fundamental right going on here. But even with that, when there's a content-based restriction, that's like the easiest test dealing with speech. So we want to focus on that. So this is really, excuse me, this is really determining where to focus your analysis. So is this state or is this law constitutional? A, no, because it treats barbershops differently from other commercial establishments. This is true. Like it is true that they're treating it differently, but that's not what we're going to rely on. What we really care about here is the fact that they're restricting the content of speech, whereas this is getting at an equal protection discussion. And there's a lot that happens where you have to differentiate. Okay, well, is this equal protection, fundamental right? Is it freedom, freedom of speech? What is it? So this you have to really classify and know where to go for your rights. So it does treat barbershops differently, but that's not what makes it unconstitutional, because just treating them differently, also, even if you were treating them differently, that doesn't render it unconstitutional. You have to show them that it fails the test also. So it's just not detailed enough, it's not precise enough. Um, so incorrect. I'm gonna say incorrect because imprecise. Focus on EPC and nothing to show. It wouldn't meet the standard, um, but I want an answer that's more detailed than that. Okay, B, no, because it imposes a restriction on the content or subject matter of speech. So that's super precise. In the absence of any evidence, and then it's getting to the standard. In the absence of any evidence that such restriction is necessary to serve a compelling state interest. So this is got our right standard and is getting at content-based speech. So this looks like a good answer. One thing that happens a lot with common law, we're going to dig into this heavily in the course, is just all the different standards, particularly separating out like speech, all the various different types of speech, etc. So pulling that out versus equal protection versus substantive due process, procedural due process, etc. So really all of those rights. But let's look at the last two. So C, yes, because it leaves political candidates free to communicate their campaign messages to voters by other means. Like this is true, but that doesn't, again, render it constitutional. So you have to really watch this where there is a true statement, but it doesn't make the result happen. So that's not a basis for finding the law constitutional. Usually we're looking for something to say that's a basis for it to be unconstitutional. We see this sort of with torts too, where like you can't say that there is liability based on one thing being met. You have to show that like, one element is not met or something. It's really like you have to show the whole answer. Sorry, that's maybe I'm gonna get into that a lot more when we get into like torts and all that too, and in comma. But D, yes, because the operation of a licensed barbershop is a privilege. They like to do this too. Just because it's a privilege and not a right isn't, again, a basis for it to be constitutional. And also, we're dealing with a fundamental right of free speech, and we're dealing with restricting that based on content, which is strict scrutiny, but it's like content-based strict scrutiny. That's another thing that happens with common law a lot. Um, it's subject to strict scrutiny, but they might use slightly different language here than they do other places. So you have to really pay attention to the language in these answer options. So D is incorrect because just because it's a privilege, it's doesn't mean it's subject to any reasonable restriction. This also is not a reasonable restriction. Also, generally speaking, when I see the word any in an answer choice, it's usually going to make it incorrect. It's not true in this case because in B, it's saying in the absence of any evidence. But here, when we're saying, well, any reasonable thing can be done, that's way too broad. All right. So let me just go back up to my other PowerPoint. I don't know that I put any. Did I put any more notes on that? Let's see. Okay, no. So a little bit easier, I think, on this last common law question. it's still a little bit there, but with con law questions, they do get really tricky because there's just so much precision in the language. Um, yeah. So, let's talk about a con law essay also, and I'm going to focus a little bit more narrowly than I have in the last couple of classes, just showing you guys one thing that I want to show you. Uh, so, how many of you struggle with individual rights, just generally speaking, analyzing it, like how do I analyze this versus that, etc. And California or UBE. It's for most people, they're like, I don't know how to do it. Like you might be able to recite the rule, but what does it look like to actually analyze it? So I'm going to show you how to analyze equal protection and the big thing that most people mess up. So give me 1 second. I'm going to pull up an essay here. This is an essay from July 2013. Let me get it up on the screen. Oh, yeah. Okay. We'll put this up on the screen here. Oh, the poll results. Sorry. Thank you. Most people got B here. All right, everybody, take a few minutes and read through this fact pattern. I'm going to make it bigger. I think it's more you have to make it a little bit bigger on your screen, Mo. Is that better for you guys if I zoom in like that? Okay. Oh, hey, Estella. Okay. Sorry, guys. Okay, good. Yeah, because I know you can increase it on your end as a viewer. All right, let me know in the chat when you're done reading. Also, tell me in the chat if you're new to these workshops, if you haven't been to one before, if this is your first time coming. New, hey. Hey, Vivian. And Michelle. And is it Chi-Chin? There's Victoria. Hey, Elizabeth and Valerie. It's so nice. And everybody that's been here before, I'm so happy to see you too. Hey, Leah. I recognize a lot of names, which is always fun. And I hope I recognize your names. Oh, oh, that's okay. Thank you, Estella. Hey, Zanetta. All right. All right. So we're going to just dig into this a little bit. Now I'm going to put this essay up on the screen. I'm going to put my answer on the screen. Okay. So not my answer. We're going to start drafting it a little bit. So a big thing that people don't know what to do. So this is a comma essay. They give us a call to question. I would just set it up here. This is a California one. Let me make the font bigger. So this is California. So I would just set this up. So 13th Amendment, let's see, due process clause and equal protection. So just setting this up, a lot of people, literally when the lectures happened from like one of the big companies, the year this was administered, the common law lecture literally like, yeah, they never test 13th Amendment, so don't worry about it. And then it literally came up on the essay, which was wild. And one of my best friends was in taking the bar exam that time. So not fun, but that's involuntary servitude, which is what it says. This is the ban against slavery. 14th Amendment due process. They don't tell you procedural or substantive, so you've got to do both. So if you didn't do that, that would have been a problem. And then substantive. And what I'm going to talk about applies equally to procedural and substantive. Okay, then we're going to talk about equal protection. So, so with this question, with this fact pattern, and the big thing that people don't generally understand is how do you argue both sides of something? And that when you're presented something like this, there's going to be arguments, oftentimes both ways, to argue that this is an equal protection violation and that it's not. So you want to look to classify what is it, what are the possible classifications for this? So if we look at this one, what is the discrimination on the basis of here? So the study indicated that the connection was most pronounced among boys, which would be gender discrimination, right? Which is like intermediate plus scrutiny. It's not just intermediate, it's intermediate plus, aged 15 to 18 years old. You could also say there's discrimination because it's not just boys, it's this select group of boys. So is it discriminating on the basis of age? So you'd want to really look at both of those. So you could say, well, and really, like it's sort of silly that you want to think about it that way, but like you've got to think if you're the state in this case and you want to argue for its legitimacy, you want to say, like, no, look, we're really focused on age. And age is subject to a different standard, right? So we're really looking for multiple classifications that fall into different standard levels. And there's pretty much always going to be, sorry, talking too much now, hard with a cold. Um, there's almost always going to be like different arguments that you can make. So equal protection, I'm going to say, okay, this could be viewed as, age discrimination, or this could be viewed, and if that's the case, here's the standard, and you're going to do the analysis. I'm going to also set it up as, okay, this could be viewed as gender discrimination, which is pretty obvious that it is. And that's really the difference between a passing answer and a good answer, right? Like you could just pass this essay by just getting at the one. You could just get at, okay, this is definitely, gender. That's really obvious. But why did they also give you the fact that it was only 15 to 18, not just boys? So it's that kind of detail that can help you A, get your passing answer, and B, how do you go from like people always say, well, how do I get a higher score? How do I get a strong pass, do really well? Because maybe you feel like you're weak in another area, but then you want to be really good in something else. So that's how you do it. So like I would set this up to be like, okay, classification, age, and then classification, gender. Okay, so I'm gonna say, okay, so here I'm not gonna actually just write it. Oh, all right, let me just finish my setup. And then standard, rational basis, standard, intermediate. And I write intermediate, but I know that the standard for gender is slightly different than other intermediates. So you want to talk about it. So that's what you would do. So you say, I would give my rule, I would type that, but just so you can see, what that might look like, let me just write a little bit of it here for you. So here, you would obviously have your rule in there too. So here, a court could find that the classification is based on age because it applies only to boys who are 15 to 18 years old. Given that age is not a protected class, um, it is subject, the law would be if the court took this approach or classification, it would apply the rational basis test. Okay. And then I'm going to apply it. Then I'm going to give my rule. And then I'm going to just do the application. Then I'm going to run through, okay, what's more likely is gender. Explain why it would be gender because it applies only to boys, not to girls or, anything else. And then apply the standard. Does that make sense? And I like to break things out. Okay, classification, this, standard, rational basis. Okay, next classification. It could be viewed this way. Uh, and then apply the standard. I just like things to be done just so like this, that like just so structurally is how I like to do it. So I just wanted to show you guys that little brief tip on equal protection. For con law, I do tend to go way deep on that class. Somebody asked where are the rules being put. The rules always go right underneath the heading. So let me just show that. So like, I would say so like standard rational basis. Um, to pass muster under rational basis, review, there must be a rational, the law must be rationally related. Oops, to a legitimate government interest. And it's really the government must show that the individual must show that the law is not rationally related. I can't type. Okay. So just a little bit of a tip. And you would need to give the rule. You would need to give the rules. I'm just filling and showing you like how you set up the arguments. But um, you would definitely give like generally speaking, we're following IRAC. So rule here and here, and you would have your analysis, and then thus, and you would have your conclusion. Due process. I would put my big rule for due process up above, or you can just get right into procedural here, etc. So yeah, you absolutely need to give the other stuff. I'm just showing an isolated small part. That's all. Um, just a little tip on like what to do and like in equal protection instances, you generally have to show not just one classification. You want to show both and apply the standards if it were to go this way. And then in your conclusion, say what is the court most likely to do? So the courts, because it literally says boys in the law, the court's much more likely to view this as gender discrimination. Um, and I've seen it go other ways too, where they're talking just about pregnancy, etc. So, all right, that's it for our class. This is a shorter one today. But as I said, for those of you that are UBE takers, next week we have another free webinar, and I will not be sick anymore. I hope, please, everybody, let's hope not. But we're gonna walk through the 6 MEEs and the 2 PTs from the July exam, and then the following week we're gonna do California. But thank you so much for joining me for the free webinar series. If you need anything, if you have any questions, please feel free to reach out. And if you haven't done a strategy session with me or booked one already, please feel free to do so if you want to talk about strategizing for the upcoming exam. Somebody had asked me a question, the difference between the MEE classes and the book. The classes, I'm going to like walk you through and really deconstruct all of the different answer options. It's going to be a really good in-depth course, really like walking you through all the various topics. So yeah. All right, everybody, thank you so much. And the link, I think we set it, I think it'll be going out in the email that we send out for everybody that came. But I can put the link to set up a strategy session as well. Hang on a second, Alana. And thank you so much, everybody. Sorry, I'm so sick today. Um, And somebody asked, do you need to include a section for standing and state action? You know, on this one, I actually really don't think you do. And most comma essays you do for California, not for UBE. Um, all right. And if you wanted to book that free strategy session with me, I just put the link in the chat. So it's there. All right. Thanks so much, everybody. Have a great rest of your day. Bye. The email for the review of the bar will be going out soon. Yes. And you can already sign up for that on our website too. It's up there with all the free resources. All right. Thanks, everybody. And thank you.